Ms. Heiser.
Yes, Your Honor. Thank you. And again, while I appreciate that deposing counsel is not, let's say, commonplace, typical. I think in this case, it's 100% warranted. And I know that the court certainly has the discretion to do that. Under the discovery rules, under Rule 26, we're entitled to discovery regarding any issue that will allow for there to be discoverable evidence. And the issue here is this. This is in essence like an attorney being involved in a case pre-litigation. When a corporate attorney is involved pre-litigation, and whether they're assisting their client or whether they're involved in communications, those are all discoverable. Obviously there may be limitations based on attorney-client privilege, but the issue here is that this email that was sent out on May 12, 2025, which is before obviously the lawsuit was filed, it's the problem with it is that if you notice, and that's why I put the entire email into the discovery dispute statement, is it says legal met with staff from planning and traffic engineering today. Okay, no idea who legal is, what that refers to. Could mean Miss Heiser, could mean Miss Heiser and a bunch of other people. It could, who knows? And then it just says with staff from planning and traffic engineering. Again, no idea which staff that is. We've tried to depose the two main people that both the city listed and that my client dealt with, Jose Padilla and Jose Trujillo and Phil Kircher, and neither one of them in their deposition could explain exactly how the decision was made, who made the decision, how it came to this point. This email, if you look at it, it's a it's like 100% clear. It says this next sentence: the city will no longer support approval of a development plan that shows driveway access from my client's property onto 118th Street. So it's a definitive statement that is saying no longer support any development plan that's got that in it. It's not conditioned on, as Ms. Heiser's argued in the past, like, oh, well, they never actually submitted a formal development plan, so it was never actually formally rejected. She's saying here it is rejected. It will be rejected no matter what you submit, which is what our argument was from the very beginning, why this has always been a taking. But long story short, my client's entitled to depose Ms. Heiser to the extent to figure out who specifically was at this meeting, the participants, that's not attorney-client privilege, and then who specifically made the final decision in terms of deciding this sentence, because it's extremely definitive. And again, we've had through discovery, we've seen many emails back and forth between the city of Scottsdale and my client's representatives, and the city has changed its position 3 or 4 times over the course of time. There was initially there was going to be access, then there was going to be temporary access, then there was going to be, well, we're not sure yet, and then this is the first time we have a definitive statement that there will be no approval, of access on 118th Street. So there's a strong basis for deposing Ms. Heiser in this case, because, as I state on page 2, Mrs. Heiser is the only person that can explain what caused her to send her email, what her involvement was in the decision, and who else in the city participated in that decision. And the actual email, which you're not allowed to attach exhibits to under the Rule 26D standard, which is why I did write in there like, hey, if we need to brief this further, we can do a larger brief. But I can just tell you that the actual email was sent from Ms. Heiser, and the only person copied on it was Joe Padilla, who is, at least at the time, I'm not sure, was another city attorney. So it's not like that the email copied one of the other non-attorney employees that I could have then deposed or or ask questions about this email. The only sender of the email is Ms. Heiser, and there's no other city employee that's aware of this email. So again, we can put limits on it, but there's no basis to say that the plaintiff should have zero right to engage in what would be proper discovery to determine what caused this email to be sent, who was involved in the decision to send this email, and that's all we're asking for. We're not trying to do anything untoward here. We're not trying to, conflict out Mrs. Heiser at all. What we're trying to do is get to the bottom of what created and caused this email to be sent on this particular day and time. So we think under Rule 26, under the cases we cited, that a deposition here is clearly warranted and should be allowed by the court.
Thank you very much, counsel. Ms. Heiser.
Good morning, Your Honor. So the email was sent pre-litigation. Mr. Anthony's not wrong about that, but it was sent in investigation of Mr. Long's notice of claim. The notice of claim requirement is an absolute necessity before anyone can file a lawsuit based on any actions of the city. And in this case, after Mr. Long filed the notice of claim, counsel met with him and his attorney, and this email was sent in direct response to plaintiff's counsel during investigation of the notice of claim. Mr. Anthony did depose staff from planning and traffic engineering, I think in May or June, and he never asked them about this email or if they were present at any meetings. But the bottom line is twofold. First of all, it doesn't share any nefarious or brand new position on the city. The exact same position of the city is why Mr. Long filed his notice of claim in the first place. And that notice of claim is attached to the complaint. And in it, he says that, Mr. Murillo, who was one of the deponents, told him that the property should be listed for sale versus via 119th Street because the city would eliminate access to 118th Street. There's no new position there. And if there was, then it was upon plaintiff to file a new notice of claim to make any sort of new allegations they had against the city based upon that email. They didn't. And Rule 26, while it does allow broad discovery, it does have in 26B3 the work product and witness statements protection, which is documents prepared in tangible things prepared in anticipation of litigation or trial, that a party cannot discover documents that another party, including the other party's attorney, consultant, insurer, and it goes on, prepared in anticipation of litigation or trial. This email falls within that category, but also there's no mystery here. There's no mystery. The plaintiff himself and Mr. Anthony has been told multiple times why this email was sent. And the nutshell is development conditions of a property are decided on the conditions that exist at the time that the development plan is submitted. It's that simple. That's Arizona law. And there is a history of this. Mr. Long purchased property in 2023 and hasn't ever submitted development plans, and conditions changed between the time he purchased it and currently and even today he hasn't submitted development plans. So there's just no basis under Arizona law to allow plaintiff to depose the lawyer where he's deposed the staff and never asked them anything about any meeting with legal or what their role was in that meeting, if they were present, anything like that. The 2 or 3 cases that plaintiff cites in his statement are all specific cases where a witness testified in deposition that they weren't either going to answer the question on advice of counsel or that they proceeded consistent with counsel's legal advice. That's not the case here. And, the city obviously objects to taking my deposition because at that point I am conflicted out from representing the city any longer to retain outside counsel. and, you know, push everything back further, especially when there's no basis for it at all.
Thank you, counsel. Anything further before the court provides its own thoughts?
Yeah, Your Honor, just just a couple minor rebuttal points. As the court's aware, under 26 B3, there's obviously an exception that those materials are discoverable if there's a substantial need for the materials to prepare its case and cannot obtain their substantial equivalent. And I disagree with Ms. Heiser's that simply by deposing her, she'd be conflicted off. The deposition of her would not necessarily make her a witness. I mean, we have the power to decide whether she should be a witness or not. We're not moving to exclude her. What we're doing is we need to find out from her who was there. And then based on that information, we then can look at those people and depose them and find out what they're doing. When she says, I never asked the question about, did you have any meetings with legal? First of all, my memory is I did, and that would be objected to as attorney-client privilege. So they have asserted privilege here in terms of communications between when the employees I deposed, if I ask them, oh, who'd you speak with at legal? That's literally asking for a conversation they had with legal. So we can't be hamstrung based on attorney-client privilege, but at the same time say, yeah, it's a secret meeting. You just don't get to know who was there, who made the final call. And again, what I urge the court is, if you look at the notice of claim, the issue is that notice of claim is filed on the basis that there is essentially a series of waffling, and there's a point where you like what Jesus says and what another guy says. There's conflicting between Mr. Kircher, Mr. Trio. The point is that this email is the first time someone definitively says, if any development plan submitted with X 118th Street will not be considered, period. There's zero condition here. It's not that, and you know, she says things changed. Well, nothing changed other than the city's position. Nothing changed geographically. Nothing changed about 118th Street. Nothing changed about Mr. Long's property. So all that stayed the same. The only thing that changed, she is right. Changes were done by the city. The city kept changing their mind about what was involved, whatever. Now she can say that the change was that they finally got some access to 119th Street, which is what the rest of the email refers to. But even that issue is interesting, because that's the whole issue. If you look at the problem, they only acquired a portion. So 20 feet of right of way, but it's not the full amount they would need to do the cul-de-sac and everything else that she referenced in that email. So again, the issue of whether of the taking issue, and whether we had to submit a formal plan when it's already been rejected in advance, whether that's a sufficient basis for the lawsuit, that's a totally different issue. We're just talking about right now today discovery, and to me, it's clear to me that we should at least be able to depose Mrs. Heiser, whether or not any part of the deposition ends up being admissible, whether or not we could call Mrs. Heiser to actually conflict her out. Those are totally separate questions. Our goal certainly is not to delay the case. My client wants the trial sooner rather than later. But we also do not want to leave any holes open to wonder. I wonder how we finally got a definitive picture 2+ years into this deal, when if this was going to be the city's position, just tell us when we did our due diligence on the property before we even purchased it. So again, I understand theoretically that like this didn't change anything relative to our notice of claim because we'd already filed it, but it changes in the sense that they seem to have a definitive approach here versus kind of more waffling approach prior to this. So anyway, that's why we think it's important.
Thank you very much, counsel. Anything further before the court provides some of its own thoughts?
Yeah, Your Honor, I would just point out that everything that Mr. Anthony said could have easily been asked in a discovery request if it hadn't been an interrogatory. I disagree that, well, actually I have two positions. First of all, if there is any claim, a new claim based on the letter that I wrote while I was investigating the notice of claim, then plaintiffs needed to file a new notice of claim. Because Arizona law is very clear that my investigation of the notice of claim is the purpose for the notice of claim, and you can't have a complaint for something that the city did without filing a notice of claim. So there's no basis. Interrogatory requests would have answered all of these questions that Mr. Anthony has, even if they weren't already in the record, and they are.
Thank you to both counsel for your time and for your efforts. The courts had an opportunity to review the record. The courts had an opportunity to hear the parties' positions here in court, and I appreciate that. Based on what the courts reviewed and what the courts heard, the court finds that at this stage, plaintiff has not shown good cause for Ms. Heiser's deposition, setting aside concerns regarding privilege and work product issues for the moment. The court finds that plaintiff hasn't sufficiently identified specific material factual information that can't be obtained through other means. Therefore, the court does not find good cause and will deny without prejudice the request to depose Ms. Heiser. And that's the court's ruling based upon the discovery dispute before it. Is there anything else the court can do to assist the parties in getting this case moving forward?
No, Your Honor. I mean, other than like we've yet to have any sort of a ADR, but I think we were trying to maybe do a private mediation, but it has yet to be scheduled. So I'm not sure whether the city, has abandoned the idea of doing a mediation or what. But if we're not going to do a mediation, I guess we would do a settlement conference. But I haven't really heard anything from Ms. Heiser regarding the mediation in many months.
Ms. Heiser, thank you, counsel. Ms. Heiser, what's your position regarding private mediation versus ADR? The court will require one or the other before contemplating a trial.
Sure. I think that we put in the joint report ADR because at that point we weren't sure which we wanted to do. I don't think the city would be opposed to get it to, if we can agree on a good mediator who's familiar with this area of law, to splitting the cost of an actual mediation. I know there's a deadline for that in probably the third amended scheduling order, which is, actually there isn't, because we have it set as a settlement conference. But dispositive motions are due September 25th, and the city does intend to file a dispositive motion. So I wouldn't be opposed to having a mediation maybe after that dispositive motion is briefed, I don't think that the city would want to do a private mediation prior to at least briefing on the summary judgment.
Counsel, what are your thoughts on timing, Mr. Anthony?
Well, I guess the concern is that I believe we already have a trial setting conference scheduled for, for December 4. So I hear that, they're going to file, apparently the city's going to try to file a dispositive motion on September 25th. By the time we brief that, that'll take us out to probably into November before even oral argument. I mean, meaning that's just the pleadings in terms of the time frame that it would take. So then I presume maybe the court would then end up kicking the trial setting conference if a motion is in fact filed. But my concern then is that we're just even pushing this case further out. So, but it sounds like they're not going to be willing to do it until it's briefed. Whether or not that means they would be willing to do one while we're waiting for the actual oral argument / ruling by the court on the motion.
Yes,
it kind of seems like, but it sounds like at that point we've already committed the money to briefing the motion. I don't know. My experience when I've gone to a settlement conference / mediation where there's a pending motion, it's just sitting out there and neither side knows yet what the court's going to do with it. I don't know how well that allows or is conducive for settlement. It's frankly better to simply have the decision in hand, because then the only thing left is trial. Obviously, if the city were to prevail, that ends the case anyway. But From plaintiff's side, we are confident that we're going to be able to defeat any dispositive motion because I already know which angle Ms. Heiser is going to take, I believe. And so we're not really too concerned about her motion or the city's motion. So therefore, we would prefer just to move forward with getting the settlement conference then just scheduled by ADR, because I believe the court can order ADR regardless of whether there's a pending motion or not. And we'd rather get the settlement conference over with quicker. We're not going to pay money for a private mediation while a motion's just hanging out there with no decision. So I'd rather just do a submittal to ADR right now and try to get a settlement conference set as soon as possible. And wherever the summary judgment briefing happens to be, it happens to be, but at least we're not paying a private mediator a bunch of money while we're trying to figure out a way to settle this case with a pending motion. Admittedly, it's going to be the same problem with the settlement conference, but we also don't want to delay because, as the court just said, you wouldn't set a trial till after we at least had one of these. So while I understand the idea that a mediation may be more successful, it would only be more successful to me if we had a definitive issue determined. Is the next phase trial or not? And I think having the motion otherwise would be a waste of time. So I would request that it just be set or be referred to ADR for the immediate appointment of the settlement conference judge. So we can get a settlement conference scheduled on the calendar, as soon as we can.
Thank you. So I know, and it may be case specific, but I know that there are different schools of thought as to what the ideal time is to have a settlement conference, and it may just depend on the specifics of a given case. What the court does require, if the parties opt for ADR as opposed to private mediation, is a certification, joint certification for ADR, and the parties can confer on that and determine the timing of submitting that certification so that the court can determine whether it's appropriate whether the case is teed up for ADR. But I'm encouraged that at least the parties, I just want to make sure that the parties are at least discussing these issues so that there can be some movement on that, whether the negotiations or settlement discussions with a third party neutral occur before or after any dispositive motion briefing, I guess will depend on what the parties see as best for this case, and determine whether they want to go the private or mediation or ADR route. But I don't want to make a decision on that issue. I recognize the differing positions of the parties, and I hope that the parties continue to meet and confer to get that requirement taken care of, so that this case can get to the finish line one way or another. Anything else that the court can do to assist the parties at this time?
Not from plaintiff's side, Your Honor.
No, Your Honor.
All right. Well, I thank everybody for your time and for your efforts. Unless there's anything else, this matter is adjourned. Thank you.
Thank you.
Thank you.
5561, matter of Absolute Resolutions Investments LLC versus Snyder. If counsel could please announce for the record.
Hi, Sam Frantantoni. I'm the attorney for plaintiff, and I'm with Gerstel Law Firm.
Thank you, and good morning.
Good morning.
This is John Parker, appearing on behalf of the defendant.
Thank you, and good morning. And Mr. Cobb, if you could announce for the record.
Yes, this is Roland Cobb. I'm the arbitrator that was appointed in this case.
Thank you very much. So the court just wanted to check in on this matter. It saw that an arbitration hadn't been ordered yet, and I wanted to check in to see what the court can do to make sure that one gets set, unless the matter is resolved otherwise.
Well, Your Honor, if I could start, this is Sam Frantantoni with Gerstel Law Firm. If the matter cannot be resolved, then I don't think there's going to be an issue setting an arbitration date between the parties. I was hoping that was the direction we were going in terms of settlement. Mr. Parker, if he can shed some light on whether or not that's the direction he is intending to go with it.
No, yes, Your Honor. I agree with what Sam is saying. We can schedule an arbitration, and if we want to do it now, it'd be great. We had briefly discussed settlement a couple of months back, but I think that's something that Sam and I can do, and hopefully we won't have to do the hearing. Thank you.
Mr. Cobb, what are your thoughts?
It's up to everybody else to, I can work with them to set some dates.
All right, why don't we do that now, just so everybody is on the same page. Do the parties have any proposals regarding? So the court previously issued a couple of orders, and I don't pretend to know what communication has occurred between counsel and the arbitrator in this matter. What the court does know is that there was orders to set an arbitration hearing, and no arbitration hearing has been set. So I want to have an arbitration hearing set, I suppose, at a minimum. And when that occurs, I guess sooner rather than later would be the court's preference.
All right. From the plaintiff's perspective, we generally need about 4 to 5 weeks lead time, just so that our witnesses are available. Generally, they're booked for the next 30 days going forward, so they ask us to please give them at least 4 to 5 weeks so that they can then schedule. So that's the only thing that we're up against. So I'm just looking at my calendar, and we could probably do November. Well, no, that's not good. Sorry. November 5th is a good date for us. Either morning or afternoon works, if that works for everyone else.
Your Honor, I need to weigh in on that because
Yes,
I am in